Hi, Bill Henshaw here again. More current news that you might be very interested in. The good old Ninth Circuit Court of Appeals out here on the left coast. And by the way, things may be changing there. Trump has apparently appointed enough conservatives in the Ninth Circuit to begin to make some differences. It didn't help him in this case, called, go figure this one out, Innovative Law Lab versus the Department of Homeland Security. And the issue here and the Ninth Circuit ruled in favor of these illegal immigrants that want to come over here and get into our country, because the Trump administration said, well, you can try to come over if you want to, but while your cases are pending before an immigration judge, you remain in Mexico until the matter is decided one way or the other. Now, the Ninth Circuit has said not so fast. They have a right to be here during the duration of these proceedings. Now, this opinion just came down, so I've not had a chance to review it totally. I'm going to do that, and if it's worthwhile, I'll do a video the next time with further details. But the important point here is the Ninth Circuit has apparently ruled that undocumented, possibly even enemy aliens, have more access to federal courts than we do, lawful de jure jus sanguinis state citizens. We can't even get in the door. The courts are closed as far as we're concerned, and you'll see, those of you who have my paperwork that you've gotten before, you're going to have updates with this issue. If the courts are closed, that means we're in a state of war, and we can't even access the courts. So we'll see about that part. But in any case, if they have more access, you ask yourself, what's the reason? And as you know, those of you that have been following my work and my videos, the crown jewel of my unopposed issues, there are no states. So these federal courts that are in territories apparently are not Article 3 judicial courts, although the 9-0 farts have ruled in a couple of cases, Ex parte Crow Dog 109 U.S. 556 and Snow versus U.S. 85 U.S. 317, that federal courts in territories have a dual jurisdiction. One as a territorial tribunal, the other as an Article 3 circuit court, judicial. If we get into that court and they are required to exist, the game is over. Simple as that. And even in territories. And by the way, this issue is a big reason, as you're going to see in the video I'll be doing momentarily here, why the New York banksters consider Scott v. Sanford to be an infamous case, probably the worst decision the court ever made. You may know it better as Dred Scott. But there was a lot of discussion there about the justices, I think particularly the opinion of Justice Taney, Roger Brooke Taney, about the fact that Congress was limited in territories, just as they would be in states. And think about this, because the territories at the time, and this is 1868, at the time we didn't have any insular possessions, although we were on the verge of acquiring Alaska at that time. In other words, territories who had no possibility of becoming states. Think here, the Mariana Islands, Puerto Rico, Guam, territories like that, the Philippines at one time, who were territories but had no possibility for a variety of reasons of ever becoming states. That's a different situation. Territories in the continental United States that were going to become states, the territories were training grounds, until such time as people had enough experience and had enough population to warrant becoming a state. And the bottom line is there that they had most of the rights that state citizens would have for that very reason, even though they're in territories. That to me is a prime cause of the war between the states. It's subject matter for another video. But that said, you can see the problem is that at the time we had judicial courts. The theory is, and they'll tell you in Harvard and Yale, that the Judiciary Act of 1911 did away with the federal circuit courts. That can't be right unless we have state courts like we're supposed to have that have a common law judicial court. In California, that's the district court, not the federal district court. District court, Article 6, Section 1. constitutional common law court recognized contemporaneously by the California Supreme Court, and that would have concurrent federal jurisdiction. If we hit that court, the game is over because now they recognize our rights, our citizenship, and attorneys, by the way, can't even come into that court unless we let them. And I don't know about you, but they ain't coming into my court. Now we get some real relief. That's the whole focus of my work for my entire life, what I've been into the last 37 years. So we'll see how that part goes. But in any event, this case certainly is going to go to the 9-0 farts. And if I'm in Vegas, I'm betting 5-2 they're going to reverse the Ninth Circuit, but that won't happen until the next term. It won't get there until September of later this year, the 2021 term. And we'll see if they accept it and if they make a ruling on it. But keep your eyes on it. It's an interesting case, and you can get it on. In fact, if you Google, what did I just say there? Innovative Law Lab versus Homeland Security. This case ought to pop up, and you can read it for yourself. Once I get it where I have it ready to go and I'll have it highlighted and some comments with it, those of you that want it, send me an email at gmail.com, and I'll send you that. So it's an interesting situation about which more later. Remember to like my videos, tell your friends, and thank you for signing up, and I will get back to you next time. Bye-bye.